So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to talk about how well-meaning employment laws can hurt the poor and discriminate. It's a real big problem, but we'll dig into New Jersey's law. It's a temporary workers' bill of rights. This was posted by Andrew Carter March 14th. And you can take a look at the link down below and take a look at it so you can understand it more. There's more information than just what I'm sort of highlighting here. And before I get going, I want to kind of note that I actually think that temporary workers, there needs to be more laws surrounding them. There needs to be more laws to help them out. If you go look at many post-colonial countries, you'll actually see that many of them have very, lengthy and very involved temporary worker laws. I mean, the registrations involved with it, the registrations and everything else that surround it are just really defined. New Jersey's new labor law first defines what a temporary help service firm, which is a person or entity that operates a business that employs individuals for other customers, and those customers are the ones who pay both the workers' wages and salaries, as well as state social security taxes and federal and state, carry workers' comp, as well as sustain responsibility for the actions of their workers during their placement. And I want to dig into this first, or I want to kind of talk about this first, which is the fact is the covered temporary labor. You can see that there's a list of covered temporary laborers. Now, almost any job can be a temporary laborer. I mean, in theory, for example, you could have there could be any number. And so the fact that they created these classifications that ultimately exclude other people sort of belies the point. Don't all people need protection? Don't all workers need protection if they're a temporary laborer? Why be so specific? Why sort of drill down to the nitty gritty? And, frankly, there's probably a lot of special interests involved in this, I imagine. Because there's no need to be this specific. If people need protection, which I do think they do, they all do, not just specific defined people within the Bureau of Labor Statistics. So let's get into the rights. One of the first rights, and there's many here, and some of them I won't cover, but is effective May 7th of 2023, the temporary help service firm has to give a required notice to the temporary laborer. And it requires a lot of information, which include name, address, telephone number of the service, nature and name and nature of the work to be performed, wages offered, etc., amount of sick leave. It continues. It's a lot, right? The problem here is this line. Both English and the recipient's primary language containing the following information. So I have worked in several multilingual work sites, one of which where English was like the sixth most spoken language on the production floor. The temporary firms that we hired to hire those speakers did not have the requisite sort of translators on site, period, for all of those languages except for Spanish, right? They didn't have a Farsi and Urdu. They didn't have Burmese, Hakachin, and languages like that. And so to require a temporary service, which operates on pretty thin margins, to provide things like the employer's name or specific things, the name and address of the assigned work site of each temporary laborer in their primary language becomes an administrative nightmare. To some level, right, you could probably create a form, right, and you would be able to draw up a form, but because that changes frequently, because you get new clients and everything, you'd be putting a lot of cost on the temporary employment agency. And as a result, are they really going to sort of hire these oppressed peoples who are not very well versed in English just so that they can pay money for a translation which can be at many times very expensive? I just don't think so. What's going to happen is it will force the temporary firms to not to decide not to hire that person, to push it off. They may sort of specialize in one language like Spanish, but not be willing to embrace some of the smaller languages, and sort of discriminate that way. And it's a really frustrating thing. This is, a required notice is a really good thing, but adding on the recipient's primary language, which in a perfect world is ideal, it, it will end up becoming discriminatory. The next piece of this law is that placed temporary laborers must still be paid even if there's no work available on that day. So they have to get a minimum of 4 hours from the temporary help service firm, even if they're not called. I'm not sure. I don't think that this will work out as well as people think. But I also don't know how frequent that is. When you're calling in a temp agency, I really doubt that you're doing things like that. But I could be wrong. I do think that obviously I like the protection, and my guess is that New Jersey has a similar protection for hourly employees who have that happen to them. And it's a reasonable protection to make. It is a little bit frustrating to come into work after 4 hours, and not have any work to do. The next one is a little bit interesting. Maybe it's a problem that I'm not aware of. I can definitely see a world where it is, but it's temporary laborers cannot be restricted from pursuing permanent work, and that's again, that's pretty interesting. I don't know if temporary employers are restricting them. The only thing that I would be concerned about is if they define restricting as, for example, refusing to let them off a specific day when they have an interview. That doesn't seem to make sense. And I'm curious specifically how it's written to sort of make considerations in this way. And here's how it hurts the poor. And this may not simply draw to many people, but it's a requirement for equal compensation and average cost of benefit. So effectively, based on this law, you have to pay a person the average cost of benefit, the average rate of pay, in order to let them be a temp. So many companies use temp employees in order to gain new employees, and give a chance to people who may never have been hired otherwise, right? It's an opportunity to prove themselves, and it's an opportunity to improve themselves at a cheaper rate. Generally speaking, the temp employees will be cheaper than a regular employee. In addition, oftentimes, there's a little bit something special if you hire a person on and bring them on because you're impressed with their work, and you give them a pay raise and benefits as a result of that. To take that away and sort of take away the idea that employees are effectively the same will cause people to not hire the downtrodden. You will want the best. You will want the absolute best because you're paying the exact same as your best, so to speak, as your employees. So you'll want the best. So there will be no excuse to not have the best. And that's where this can hurt the poor. You'll end up not giving a chance to a person who really needs it because you have to pay everyone the same. And that is how this law, is really well meaning. I understand why you would do that. I understand the value that this brings to an employee, but I also understand what the impacts could be, and people need to understand them. Law takes effect May 7th. For most of it, the law specifically surrounding pay and equal pay takes place on August 5th. So what do you think about this? I think it's an interesting concept. It's an interesting idea. And again, temporary workers need more rights. We just have to do it in a measured way that doesn't hurt the poor and discriminate against immigrants and people who are unlikely to be successful from it. What do you think about today's video? Please comment down below, like, share, and subscribe. It really helps out. And I'll see you on the next one. Bye, guys.